This is Judge Greenberg. I can't hear you.
Because I don't think we said anything yet, Your Honor. Can you hear us?
Yeah, I can hear you, but did you convene the court?
Yes.
I didn't hear that.
I think we're all set. Is that right, Mr. Block?
Yes. Well, why don't we proceed? We're in the matter of Purpose-Built Families Foundation against McDonough. Will counsel, beginning with Petitioner's counsel, enter their appearances?
I'm Alan Grayson, Your Honor, here for the petitioner. With me as co-counsel is Brittany Rosen, a 100% disabled veteran.
Okay. Right. The government.
Judge Ronen Morris for the secretary, and with me is Melissa Timbers, deputy chief counsel.
Thank you. All right. Would you like to reserve any time, Mr. Grayson? I didn't hear that. Sorry.
Thank you, Your Honor. I have reserved 10 minutes.
Thank you. Proceed with your argument.
May it please the court. I'm here on behalf of a foundation who has had its grants terminated, an unusual scenario for this court to consider. Nevertheless, the court has the authority and on this record should, in fact, stay the termination of those grants while the appeal is proceeding from that termination. By appeal, I mean the proceeding before the Board of Veterans' Appeals. The government concedes that this is the proper course, that we're properly before this court. The issue before the court is two. The first issue is whether the record establishes irreparable harm if the court withholds its relief today. The second issue is whether this court has the authority to stay pending appeal. The government has done little, if anything, to rebut our case on this record that there is irreparable harm if there is no stay of the appeal pending decision by the BVA. We have submitted 9 affidavits that are properly before the court, all of which demonstrate that this foundation will be out of business and no longer being able to provide the services that it provides, including suicide prevention, to hundreds of veterans in South Florida if the court withholds its relief that's requested here.
Mr. Grayson, could I ask a procedural question?
Yes.
So, in some of the papers in the Southern District of Florida litigation, and I think maybe in the 11th Circuit briefs, there was a suggestion that there was going to be a request for stay directed to the board as well. Has that happened?
Yes, but as far as we could tell, the board hasn't even docketed it yet. And this court, according to the U.S. Supreme Court, has inherent authority to issue a stay pending appeal. It is correct that the board may decide in favor of granting a stay pending appeal. Does not change the fact that we have the right to file a petition here as the government agrees.
Yeah, well, I'm not even to the point of figuring out what the import, if any, of a pending motion before the board is. I just needed to know whether there in fact was a pending motion that had been filed with the board.
Yes, and I'm sure that every member of this court is familiar with the problematic nature of that.
In my time here, I've never even heard of a case even remotely similar to this, so I'm going out on the ice by myself now. So, could I direct you to the part of this that is most important to me, just speaking for myself, which is assume that I'm with you that there is authority under some source, under some circumstances, to issue this type of relief, okay? Meaning a stay pending appeal. As I read the case law, the stay pending appeal standard is roughly the equivalent of a preliminary injunction. At the standard for a preliminary injunction, do you tend to agree with that?
Only proceeding under Rule 8. I do not agree with that if we're examining the court's authority under 5 U.S.C. 705, which only requires irreparable injury, not the other three tests, or if we're proceeding under the Supreme Court's decision in Scripps-Howard, which only requires irreparable injury, not the other three tests.
Well, but wouldn't it, it would have to be the case that under any source of law that the person would have to show that there is some chance that they're going to win, right?
Actually, the Supreme Court has answered that question and said that what the court needs to think about is what will happen if they win. In other words, is there irreparable injury in the meantime? So, I mean, if you're asking me a sort of metaphysical question, I guess maybe one would have to show some possibility of winning. But under the Supreme Court's specific decision in Scripps-Howard, that is not part of the court's examination. The court has to look at what happens between now and the end of the case, and if something really bad is going to happen, if no relief is issued, and then the appellant ends up winning the case.
Let's just assume that I think that Winter versus National Resources Defense Council affects that reading of Scripps-Howard. I know you disagree, but let's just assume that for a moment. I want to ask you about the likelihood of success on the merits.
That's fine.
So my first question is narrow. In your opening papers, you make an argument about the fact that the termination letter, the operative March 9th, 2023 letter, came from somebody who, under the law, was not an appropriate official to render a termination. Do you recall that argument?
I do.
Okay. We have not been able to find any authority for legal authority for that point as it relates to the grants, or sort of factual support for the notion that if there were such legal authority, Mr. Q, and I might be pronouncing that wrong, was not the appropriate official. Can you help me on that?
Sure, but please bear in mind that's about 5% of our argument on the merits, maybe less. But yes, Mr. Kuhn did not sign any of the other grant papers that relate to the issuance of the grant. We never received any notification from the VA that Mr. Kuhn had substituted for the issuer of the grant officer, if you will. In the case of a contract, it would be a contracting officer. So I'm going to call the woman who issued the grant officer. So from our visible perspective, Mr. Kuhn did not have either actual authority or even apparent authority to do what he did. But there's many other arguments we made on the merits, particularly on page 15 to 20 of our opening brief, that show that the entire process was tainted by two very fundamental mistakes. One is that none of the money issues in this case actually have been shown to have any merit whatsoever. And the second is that if you assume that there was actually unallocable or unallowable costs here, or undocumented costs that were actually paid out by the foundation, they were all approved in advance. They were approved in advance, Your Honor. And third, none of that, even if it were all true, justifies a termination under the relevant regulations, both the government-wide regulations of 2 CFR 200 and the specific regulations of this grant at Part 62 of the VA regulations. So we have, if I may say this, Your Honor, an overwhelming case of success on the merits, and that's far more than we need to show by anybody's standards, including the four-part test. We need to show something, if the four-part test applies per se, something like a likelihood of success or the possibility of success on the merits. The VA has never even rebutted our arguments on the merits of this case.
So When you say that the costs were approved in advance, or the issues, the expenditures were approved in advance, here's what I'm struggling with, right? We need to, if I were sitting in a district court, I'd have a hearing, I could have somebody on the stand, right? We don't have any of that. And so is there evidence in the record that establishes that?
Yes, there are 9 affidavits in the record, and also the representations of counsel in dozens of submissions, both in the district court, in the Court of Appeals, which you've read, below, here at the BVA, and now here as well. And these are statements that are, unchallenged. I mean, for instance, in the example that you give, the VA has never suggested they didn't agree in advance to all these expenditures.
Well, so when you say that, what do you mean exactly, right?
Well, what I mean is that the foundation gives an item-by-item list in its budget of what it's going to spend its money on, and that's approved in advance. And for the past 2 years, individual items have been approved in advance.
And does that cover everything that was found in the audit?
Yes, it does.
Well, but see, and this is what I mean about the devil being in the details. That couldn't be the case, right? Because are you saying that the government approved in advance the use of a personal credit card to pay expenses?
Okay, let's talk about that. This is during COVID. There were veterans who could only be housed at hotels. The foundation doesn't have a credit card. So individuals who worked for the foundation advanced that money on their own credit cards so that these veterans would not be homeless. That's what happened.
Yes, and that might be laudable, right? And it may even be lawful or not problematic under the grant. I'm focused now on just this one thing, right? That was not approved in advance.
The expenditure was approved in advance, and there's no regulation or policy or a statement by the VA that that's an inappropriate thing to do. After the fact, it was a questioned cost by the order, a questioned cost. That's all that happened. Now, people can question things all day long. That's not the same as saying that it was violated, that the foundation was violating the terms of the grant, because they weren't. There's nothing in the grant's conditions, there's nothing in the regulations that say that in a situation like that, you're not supposed to use a personal credit card because otherwise the veteran's going to be homeless. That doesn't make any sense. I mean, why are we here? Why are we here? All of us. We're here to make sure that veterans are served. If an auditor wants to come back and question the use of a personal credit card when there's no alternative, I think we have to think of A, the law, but B, the higher purpose as well.
If I may.
Yes.
Weren't there some expenditures that the foundation agreed were inappropriate? For example, the Netflix, and I think there was a coffee expenditure. And so I mean, to Judge Allen's questions, you're representing that all of these expenditures were pre-approved, yet in the record, there is a concession, if you will, from the foundation that some of them were not only pre-approved, but also inappropriate expenditures. So it doesn't seem like it can be both ways. I mean, either all of them were pre-approved or some were, others weren't.
When the budget is submitted, they're approved. For the last 2 years, individual items are approved in advance. Obviously, anybody can make a mistake. All right? Now, the papers mention that there was a situation where what was posted to this grant was found after it was flagged for us not to be a proper charge. And the foundation quite honestly admitted that and is willing to repay anything, the very small amounts like that are in dispute. But the regulations tell us what to do in that situation. The regulations provide the answer about what to do if somebody makes a mistake in bookkeeping. And the answer is not terminating the grants. You can't do that. Just look at what the regulations say. Look at the first 15 pages of our brief, our opening brief, and you'll see that that's just not permitted under the regulations. These are money issues. They're dealt with as money issues, and not in terms of cutting your head off.
Can you hear me, Mr. Grayson?
Yes, Your Honor.
Sorry, Mr. Laurer, did I interrupt your questioning?
No, thank you, Judge Greenberg.
Okay. Aren't you saying, Mr. Grayson, that on balance, the equities far outweigh anything else in whether we should stay our hand or issue an injunction?
Yes, Your Honor, and I think that's where the law is. That is what the law tells us.
Would you be able to, you're making your argument, and I don't want to preclude you from making it as you had planned, but could you give us the holding you would like the court to reach with a brief emphasis on the specific facts that lead you to conclude that, assuming we decide we have the jurisdiction, should exercise it, issue, in my view, an injunction?
Yes, Your Honor. First, we'd like the petition to be granted. Secondly, we'd like the motion to be granted. We would like a finding from the court, although I don't think it's absolutely necessary, that we have shown a likelihood of success on the merits. I don't think that that's actually required under the legal authority, but I'd like to see it, and I think we've earned it by putting 9 affidavits into the record. Secondly, I'd like, and I think this is important, I'd like for this court to find that there will be irreparable injury if the court stays its hand and issues no relief. Here in the courtroom today are 5 employees of PBF, the foundation. I've introduced one of them already. All 5 of them will lose their jobs if the court does not grant relief. I think that that's reflected in the record. I'd like to see a finding to that effect. I think that the court also should find that there is no harm to the VA, quite the opposite. We have demonstrated in the record before this court that hundreds of veterans in South Florida will lose their benefits, including suicide prevention benefits, if the court doesn't act. And this is unrebutted in the record. We've put in evidence, the other side has put in argument. Just argument without evidence. And finally, I'd like the court to conclude, although again, not required by Scripps Howard or by 5 U.S.C. 705, that it's in the public interest for this court to go ahead and issue the injunction that you're describing. And yes, I do agree that it is an injunction.
And is it your argument also, in addition to what you've just argued, that is entirely consistent with the congressional scheme favoring a particular class of litigant veterans?
Yes. There is no dispute at this point about the fact that this case is properly before this court. It's easy to understand why, if hundreds of veterans are about to lose their benefits, it's properly before the BVA and this court. The government has properly cited, the Secretary has properly cited in one of the footnotes in its brief why that's the case. And for sure, a class of veterans has their benefits, very important benefits, homelessness benefits, suicide prevention benefits, at stake here today.
Anything else from Judge Allen?
No.
Dr. Laurer?
Yes, please. A question related to the impact. The petitioner, and I'll direct your attention to the petitioner's motion for stay at page 14, footnote 13, states that neither of the 2 other local VA grantees has the capacity to absorb this, meaning the SSVF work. How did the foundation determine that? I mean, it references over to another statement from the CEO, but I've read that statement and I don't see that covered in the statement. Can you explain for the court how the foundation determined that?
Yes, Your Honor. Happy to do so. What happened is that when the VA tried to reinstate the termination after the termination last year that was restrained through a temporary restraining order by the district court, what happened is that a couple of months ago, they tried to take the work that the foundation had and push it over to two other local organizations who basically refused it. And that's how that was determined. Now, I agree with you that that's something supplemental to the record. If the court wants us to supplement the record to make that clearer, I am happy to do that. And if that's pertinent to the court's decision, I think it's a good idea.
Just a minute, Mr. Grayson. Do you think you've already submitted enough for us to act and hold in your behalf?
Yes, and the reason for that, yes, Your Honor, we have, because I have made a representation to the court of the facts that we just discussed. So I don't think that it needs to be supported by an affidavit. If the court wants me to, I'll do that. But I've made that representation. It's in the record now before the court as a representation of counsel. So I think it is sufficient, Your Honor.
Judge Greenberg, Judge Laurer, did you want submission to the court, the supplemental, per your question?
Thanks, Judge Greenberg. The point I was making is that we do have a footnote which represents, I believe it's Mr. Eisenberg's statement, but we don't have anything else. I'm not questioning counsel's statement here in court, but I did have a question about where that information came from other than the footnote itself. So I do have some additional questions. I think Judge Allen may have a question related to that, but going to the irreparable harm issue.
We're just add 5 minutes. This won't come out of your rebuttal time.
Thank you very much, Your Honor. I appreciate that.
Go ahead, Judge Laurer or Judge Allen.
Thank you. Judge Allen said he had unrelated questions. So if I may, Mr. Grayson, do the 3 grants in question here under SSVF fully fund the salaries of any of the foundation's employees?
Yes, at this point, all of them.
All 50?
Yeah, that's my understanding. I mean, as the government's pointing out, 10% of the grant goes to overhead. So some of those employees are overhead employees, and some of them are direct service employees who are providing the services that are involved here. As far as I know, the foundation has no other significant source of revenue at this time. Its GPD grants have been terminated, but the termination of those grants did not threaten the existence of the organization the way that the termination of the SSVF grants do.
So these 3 SSVF grants are 100% of the total income stream for the foundation?
Virtually 100% at this point. The grants that were terminated separately were significant. The GPD grants were significant, but those are gone now. This is an organization that is devoted to providing veteran services funded by the VA to South Florida. That's what it does.
Thank you.
Thank you, Your Honor.
I had an unrelated question, and I'll ask Mr. Morris this as well. So is there any connection or impact, rather, about the ongoing appeal in the 11th Circuit that could affect this?
In my opinion, no. I would say that it can't affect this at this point. The 11th Circuit is determining whether the withdrawal of a termination letter undoes that as a final agency action under the APA. That's different from what's happening here. If we win that appeal, then there may be a remand to the district court, but that's a very hypothetical at this point.
So the briefing in the 11th Circuit then is focused on the other grants? Is that right? The ones that the district court found were not final agency action, as opposed to these grants at issue here, which were the subject of the district court's mootness argument? Is that right? Are you following what I just said? What might have been mixed up there?
It was the beginning of the question. I'm not sure I could agree with the focus. I think that both of them are properly before the 11th Circuit. But
that was my question. Is there, in your view, are your client going to be pressing in the 11th Circuit an appeal with respect to the mootness of the challenge to the grants that are now before us?
Yes, and that's reflected in the briefs that we've filed. But again, at this point, that's a very abstract question for the 11th Circuit. It has no, practical effect here. For instance, we haven't asked for an injunction pending appeal, because that would be properly before you all and the Board of Veterans' Appeals, not before the District Court or the 11th Circuit.
Thanks.
You're welcome. Now, I say we haven't asked for injunction pending appeal. I meant from the District Court. Sorry.
Do you have anything further at this point, or would you like to pass along your argument to the rebuttal? I think we understand.
Thank you. I just want to say this. To some extent, I feel like I've been sort of caught in the middle here between an ongoing argument between this court and the Secretary. I come fresh to this. I've never had a case before this court. I have never had a case like this before. But it seems to me that what's happening is that the Secretary is trying to get you all to cut back on the Roboto case, your rulings under Rule 8, and so on. Now, I come to this fresh, and to me, it seems that you have more authority than what you've asserted so far, not less. I think you have authority under 5 U.S.C. 705. I think that you have authority under the Scripps-Howard case. But I am not the best person to be addressing what appears to be a struggle that goes through many cases since 2007 between this court and the Secretary. What I can address is that my client will be shut down, 50 people will lose their jobs, and hundreds of veterans will go without suicide prevention and without housing if the court fails to act.
Thank you very much, Mr. Grayson. All right, we'll hear from the government.
Thank you, Your Honors. May it please the Court. Your Honors, it's the Secretary's position that this Court does not have the authority to grant the extraordinary relief that the petitioner is seeking here.
Speak up.
Yes. It's the Secretary's position that the Court does not have the authority to grant petitioner the extraordinary relief that petitioner is seeking. And that's for the three reasons identified in the Secretary's response, which is that the requested relief is not necessary to protect this court's jurisdiction or prospective jurisdiction, that granting the requested relief would be inconsistent with the statutory scheme created by Congress, and that there are no benefits or actions on the part of the Secretary that are being unlawfully withheld or unreasonably delayed.
Before you go on, I hate to jump in at the beginning, but it's the same question I asked your friend on the other side, which is, so a motion has been filed before the board seeking a stay as well. Is that your understanding?
I don't dispute that. I'm actually not 100% aware. I do. It does appear that the case has not yet been docketed, so it's unclear what will be on the docket. But I have no reason to dispute that.
Okay, so what is your understanding? Just assume that for one of us, there's something about the fact that there might be a motion seeking this request before the agency, right? That's important. That's me. Okay. What is the Secretary's position about how the board handles that? I mean, in other words, I understand how it works here, because we've got a lawyer on one side, we've got you on the other side, we've got the judges in the middle, and we're going to have this adversarial dispute, and we'll come out with a decision. How does something like that work before the board?
Your Honor, I'm not sure that I can give you a clear answer because I'm not sure that I've seen anything like that in the past. It's certainly, the circumstances of this case are very unique.
Yes.
And on top of that, the procedural actions are also very unique. So I am not entirely sure how the board would treat the motion, whether it would require an evidentiary hearing of some sort.
Here's why, I'll just tip my hand about why this is important, and I'll get out of your way, I promise, okay? Which is that I am looking at this through the lens of the All Writs Act. I understand that there are other sources of potential authority, but I'm looking at it through the lens of the All Writs Act. And something that the parties haven't touched on a lot is whether or not there's an adequate alternative administrative means, right? So if there is what do you think about this question, okay? If there is a pending motion before the board, and you and I are on the same exact page, we have no idea how the board is going to handle that because this is just not an everyday occurrence. But there is pending relief that would arguably make what we do inappropriate because the agency can do the same thing. Why should we not simply hold this case pending the board figuring out what it's going to do? It might not have to decide it, but figuring out what's it going to do with this, because otherwise we might be ruling in a case in which there very might well be adequate administrative means to seek the relief. Do you see what I mean?
I do. In that regard, petitioner could have also asked the secretary or the VHA or the program office to state the effects of the termination. In fact, the VA had agreed to temporarily do that, specifically waiting a decision from ultimately this court on that very question as to whether a stay was appropriate. The board, it is not clear what the board will do in this case, but staying these proceedings, awaiting a board's disposition of something, Your Honor, we don't believe would be appropriate. And part of that reason, Your Honor, is that we believe that the court should act urgently because we significantly disagree with the petitioner's view of the potential or, in their view, lack of harm to veterans.
Let me follow up with that, though, right? Because this is such a weird procedural posture, right? And I'm not laying this at the General Counsel's feet, right? Because you had the government of the United States represented by somebody else when certain apparent deals were made about this, right? Because it seemed like some of the papers to the 11th Circuit and the Southern District, particularly the 11th Circuit, the government suggested that they had agreed to hold the termination, the effect of the termination, pending the filing of this action in this court, but also the action seeking relief before the board. So is it the government's position today that were we to deny this, even though there's a pending motion before the board, that would be enough to let the terminations go forward? Or was the government's agreement before that until both avenues are exhausted, the terminations remain on hold?
It's our understanding that an order from this court would end the voluntary agreement.
And that might be right, because we're just, looking at footnotes and briefs to the 11th Circuit, but has this, I'm not being pejorative when I call it a deal, I can't think about a better way to put it, has the arrangement between the government and the appellant, the petitioner, been memorialized somewhere other than in footnotes to other courts?
Yes, Your Honor. We do have it is, I believe that it can be provided to this court. I'm not sure if it's a product of party negotiations or something that would otherwise typically not be submitted. But there is a formal writing. It is a very informal drafting of language that is, I believe it was executed via email without signatures on it. It was a quick draft. And that copy does provide that the voluntary agreement would end on whoever rules first, whether it be the board or a decision or whether it was this court ruling on this particular motion. And a lot of it that's reflected in that agreement is a lot of, a lack of full understanding of this court and this court's process. But the idea was that an action was filed in the federal district court that the government and VA believed was inappropriately filed in that court. So the idea was to take everything that was filed there and move that here.
So did the government, my reading of the docket in the Southern District, and interestingly enough in the 11th Circuit, the government didn't appear to make a subject matter jurisdiction argument, did they?
I believe there's a note in the government's motion to dismiss that references this court's jurisdiction and then the appealability to the board. It was at the basis of the government's motion to dismiss because, and perhaps to answer a question that you had asked Counsel, it's the same grants that we're talking about or at issue there and that are at issue here. What happened then was there was a notice letter that was sent out, and that notice letter was appealed. The government's position was that they were not final agency actions, and then ultimately those notice letters were also withdrawn anyway. And new notice letters were issued, a final decision by the agency, and those were issued, and those were then appealed to the board in this case. So the argument was not necessarily made because, again, there was no, by the government's view, there was no final agency action over which any court could have had jurisdiction.
And you agree that the board has jurisdiction to consider this appeal, right?
Yes, Your Honor. We believe that, especially under the Federal Circuit's holdings in Bates and Ashford Hospital, that yes. And I'd note, though, that is very specific to the SSVF grants, the grants that are at issue here, because they are unique grants that provide benefits to veterans. And they move through the organization, and so the purpose there is to provide the veterans with benefits. So we believe that under that and under the Federal Circuit's case law, that it does fit within the administrative and process and the BJRA.
And just out of curiosity, do you think that do you understand that the board would have the authority to grant the motion? I granted, I haven't seen the motion, but to grant the motion to stay that has been filed before the board? I understand that the government would say that the board should not grant that, right? I'm not talking about whether it should or shouldn't. Does it have the authority to grant that motion?
I'm not sure that I have an answer for you because I'm not sure that, this wasn't a question that was necessarily raised or at least in our view, is not something that was raised, and so it hasn't been fully fleshed out. I'm not sure what position the board would take, and I'm also certainly not sure what position an individual law judge might take on the.
Well, and would this be that I know that this has to be annoying because I'm asking you questions that you don't know the answer to because nobody knows the answer to them, I think. But so is this the type of motion that would be more like that the board, do you think, could possibly treat more like something like a motion for advancement on the docket? In other words, that before a case is assigned to a VLJ, it would be referred to the deputy chairman or whatever?
Honestly, I'm not sure, but I think that the struggle here is perhaps indicative of why just this relief generally may not be available even at the board, that there is a very specific statutory structure that was created. And yes, the board is authorized to address motions, and I don't believe that there is any caveat to what a party can seek, but it would similarly seem to interfere with the process itself.
Yes, but wouldn't it, but if we are proceeding under the All Writs Act, and the board could, because you can't speak for the board and I can't speak for the board, right? The board could, let's just assume, could grant this motion, then it seems like that would be a reason to say that there's an adequate alternative means to deny or to hold, except for the fact that now if you tell me that this agreement suggests that if we rule first, the agreement goes away, then that doesn't make it adequate because the harm can automatically happen, right?
Yes, and then I suppose to either party, if the court were to rule quickly and grant the relief, then that would happen first. But yes, certainly for the secretary, were the court to rule, that would be the final dispositive end.
So I'm assuming, and of course the chance of this happening is really, almost zero. Actually, it's below zero, but I'm going to ask it anyways. You would be able to represent on behalf of the VA that if magically the board, in the time that we were sitting here in the courtroom today, denied this motion, VA would at least notify the court in terms of our ability to act. In other words, the board really, under this agreement, it seems like the board could try to moot what we're doing. I'm assuming the secretary agrees that the court would at least have to know before that you did something to terminate, right?
Yes, so we would certainly notify the court of anything that could potentially affect its jurisdiction or rulings in this case. But perhaps, Your Honor, the reason that this was not our focus, notwithstanding just the sheer uncertainty of that, and the uncertainty then as to whether that might be the extraordinary instance where something could be appealed then to this court, and all of those issues, it's the Secretary's position that just simply put that the All Writs Act is the court's only source of authority, and that the court's authority does not extend in the way that the petitioner seeks, that it simply doesn't authorize the court to issue the type of injunctive relief that petitioner seeks without that actual harm or threat to its jurisdiction.
So here's where I need to make sure that be precise, right? Because there's two ways to take what you just said, and two ways, and I think you make both these arguments in your brief, and that's legitimate. One is a categorical argument, right, that the All Writs Act simply does not allow this type of relief, period, end of story. The other is the All Writs Act could allow this, but the evidentiary showing here of, my words, not yours, the corporate death penalty is insufficient. Are you making the latter principally?
No, Your Honor, I actually think it is the former first, in the sense there's clearly, there's certainly an overlap, because the irreparable injury would, on the one hand, be the basis for the thwarting the court's jurisdiction, but also is relevant to the merits of, an injunction or stay. But it's our position, I think, foremost, that the idea of simply incurring an irreparable injury is not itself a threat to the court's jurisdiction, that under the All Writs Act and under the cases cited by the petitioner, that there has to be that threat to the court's jurisdiction. And what we're talking about here, Your Honor, it very much raises separation of powers issues.
So let me stop you. I agree. But let's just take the most extreme hypothetical, right? That there is an entity that does one thing. 100% of everything the entity is restricted in this, and once its grants are terminated, just assume that the entity goes away, And I understand you make some arguments in the brief, bankruptcy related, right? The estate continues and all of that, right? But it would be the equivalent of something effectively going out of business, and particularly if the entity deals only with the government, because then you have you're besmirched, right? What I'm trying to get at is there some scenario under which the All Writs Act would preserve the court's prospective jurisdiction, because otherwise the ability of the entity to be viable is simply so bad that it's gone?
I believe that that exists in the hypothetical world. I am unable to envision those circumstances, and I would suggest, though, that it wouldn't simply be the closure of a business, that there would have to be more. And I would further suggest, Your Honor, that to the extent that the Supreme Court has recognized this judicial right under the All Writs Act to intervene prior to the completion of agency review, those were exceptional circumstances that the Supreme Court itself recognized were exceptional, especially in Dean Foods, Your Honors. And we don't have anything comparable to that. What we have here is the inherent natural effect of the grant termination. Any grantee whose grant is terminated, whether by VA or any other federal agency, will stop receiving those funds, and they will then stop, the fund-related activities. So this is not an exceptional.
But so here's the problem, and again, this is not laying at the general counsel's feet, because the government was represented by different counsel, right? But the government seemed to say below in the literally south in the Southern District of Florida that that you could seek a stay here, right? And so if the government's argument now is, yes, you can seek the stay, and it's theoretically possible you can get it, but the evidence you're showing here is not good enough, that's entirely consistent. But if the government's position now is you just can't get it, that, it seems to me, might be a little bit of a bait and switch.
And Your Honor, so to clarify, I am not suggesting that there is no circumstance ever that could satisfy the All Writs Act requirements for the court to intervene. However, that is not the case here, and I do question whether, even assuming that the petitioner's business would close, and even assuming that the petitioner is no longer able to operate, that necessarily would translate to an impediment to this court's jurisdiction, which again is based on, is limited to a review of final board decisions, and there's no obstacle to the issuance of a final board decision here. On the facts, the petitioner hasn't even explained at what point this business would close, whether it would be immediate, whether it would be over time. The petitioner hasn't explained how that closure would prevent it from pursuing its remedies through the administrative process, or how it would then be thwarted from bringing an appeal of a final board decision to this court. And again, the circumstances in which the Supreme Court has recognized this court to intervene prior to the completion of agency review are extreme and very, very limited. Again, in Dean Foods, it was to prevent a merger. That merger, once it happened, would have entirely defeated the agency's charge of reviewing the lawfulness of that merger, which entirely would have defeated the jurisdiction of this court. We have nothing comparable to that. So unless there is a circumstance that's presented, then ordinarily this theory, this request for relief would always be improper, unless and until there is some circumstance that would fit those types of extraordinary circumstances.
And Mr. Morris, pardon me, hasn't the counsel for the petitioner represented that they're going to be out of business unless injunctive relief is granted? Isn't that the same thing as in Dean's Foods? Irreparable harm, you're gone. No money to pay the employees, no money to give the services to the veterans. What's the government's position?
In Dean Foods, it was the federal government that sought the injunction so that the federal government, the agency, the FTC in that case, could actually accomplish its responsibilities. Not because it would have just been harmed but because it could not render a decision on the lawfulness of a merger once that merger was completed. And once that merger was completed, because the FTC couldn't issue an order, there was no final order of the FTC that the reviewing court could have reviewed. So it was those circumstances, not simply the idea of irreparable harm, but it was actually the defeat of the court's jurisdiction by virtue of the inability of the federal agency to engage in its required activities. But to the extent, again, that the...
Keep going. Sorry, keep going.
Even to the extent that the petitioner has alleged this closure of the business, again, certainly don't believe that a mere representation that a business will end would be sufficient, especially for the type of interference into the administrative process that the petitioner is asking for. And on that note, I would like to highlight the petitioner's reliance on Scripps Howard is incorrect insofar as that case clearly it concerned the stay of an agency order while that order was on review by the court, and not the court interfering prior to the completion of agency review or while the statutory administrative process was still proceeding. And again, in this case, unobstructed. There's no obstacle preventing the petitioner from ultimately seeking an appeal of the board of a final board decision here.
Well, when is that going to
Could I ask
come?
one more? Go ahead, Judge Greenberg.
Yeah, well, when is that going to come? You don't have any means of representing how promptly that's going to be? Are you going to take a position as general counsel to the secretary they ought to move on it in a particular period of time? Or should we, on an interim basis, give them a limited interim period of time to act? I mean, we're here to see that ultimately justice is done consistent with law and equity. Equitable relief includes an injunction. Everybody's worked very hard to get here, and I just can't see us abandoning the playing field without knowing something more about what the secretary intends to do. Answer that.
Your Honor, the secretary is bound, or the board at this point is bound to process the appeal in its docket order unless and until there's a motion for an advancement, and that's ruled on. This is the system that Congress created. As the secretary noted in his response, Congress could have allowed this court injunctive authority. Congress could have enacted a statute similar to the APA statute that that petitioner is relying on. It didn't. What it did was it created a very clear process for seeking administrative review and then review of that final administrative decision to this court. And this court cannot simply intervene in that without actual authority. And the only place that authority comes from would be the All Writs Act, and the All Writs Act can only be invoked when there is a threat to this court's prospective jurisdiction, not out of equitable considerations generally.
So can I just take you back for 1 second? Again, you may not have any answers to these, but if the court hypothetically were to issue an order asking for some more information, I mean, I don't know, and you don't have to tell me discussions, if at all, that you have had at all with the board, but to me it matters. So, for example, I mean, is it your understanding that this is it's got to be an AMA appeal, right?
Yes.
Okay, and so the letter seemed to suggest that the letter that provided the appeal right seemed to suggest that not all the options were available, which I'm assuming obviously a supplemental claim, maybe even higher level review. So it was direct to the board, right?
Correct.
And so do we know which of the lanes at the board this thing landed in?
I believe petitioner requested a board hearing.
Okay, a board hearing. So we're talking years before that is adjudicated. Is that right?
That is correct, Your Honor, and that may be a while until there is an adjudication. But we also have to remember that what we're talking about here is it's a time-limited grant. We're talking about the continuation.
No, that's my point, right? So I'm trying to play this out, and again, I might be the only one in the courtroom for whom this matters, right? But Okay, so it's a 1 year grant, is it? Because we don't actually have the grants. It's 3-year grants. Okay, 3-year grants, right?
It's a 3-year contract that I believe is funded specifically on a year-to-year basis, but yeah.
Right, okay. So basically, it's funded on a year-to-year basis. It's time limited. We're at least 1 year into this grant, right?
Yes, we're in the second year.
We're in the second year, okay. So is this thing going to end up being mooted at some point? Because the board's not going to decide this termination question before the grant expires, right?
No, we don't believe it would be mooted for several reasons. One, to the extent that the court granted this motion, it would actually be effectively awarding the petitioner the full grant. But the opposite isn't true. So if court, with a termination, there are several consequences. One of those is the reporting of the termination and its impact on the ability of a grantee to secure grants in the future. So that would not be moot. The impact of a termination wouldn't be moot on the petitioner. Their ability to secure further SSVF grants wouldn't be moot. Their potential ability to maintain a priority status within the SSVF program office wouldn't be rendered moot. So there would still be, the primary injury here is just that. The primary injury is that inability to re-engage in potential grant-funded operations.
And we don't know whether the board is going to treat the motion that was filed like a motion for an advancement, right? As opposed to it sitting with the file until it goes to a VLJ.
At this time, we do not, and I think that there are legal arguments on either side as to whether the board might have the type of authority to grant the relief, but there's also significant arguments on the other side that the board would not.
But would anybody be arguing on the other side in the board?
The board itself, meaning that if the board were considering its own authority, it's unclear where it would necessarily come down on that. So the quickest route here is for the court to decide this, and I would like to emphasize that, again, going to the petitioner's point that if the court terminates or allows the termination of this award, that veterans are not going to be served, that suicide prevention benefits aren't going to be given. That is not true, Your Honors. Part of the termination requires the transfer of these grantees to other of these veteran families to.
Have they been transferred or procedures made?
They may not be. The petitioner was informed of this because the program office has a very clear set of.
I bet you that, I see you looking at the clock, Mr. Morris, I bet you that Judge Greenberg is going to let you have a couple of extra minutes.
Yeah, of course. Add 5 minutes.
There are very clear procedures for what happens when there is a termination. While that termination is stayed or the secretary can't enforce it, those procedures can't be put into place. So these veterans are still with the petitioner's organization, an organization that has been found by a VA audit to have misused, misappropriated, and mismanaged those veterans' benefits. The harm to the veterans here is by allowing them, by judicial decree essentially, to remain with a petitioner who has been shown to have mismanaged 85% of the costs that were considered.
Although, to be fair, right, about this, right, the government agreed to allow that situation to continue for a period of time,
and
right?
I believe I do believe that the expectation at the time that the government entered that was that this would be a quick decision, as it would be in a district court. But either way, it was viewed to be a very temporary solution.
So could you, to go back to my hobby horse, would you then agree that there isn't an adequate alternative administrative means here, at least with respect to the motion before the board?
I'm not sure I can say that, because I'm not sure that I can say that the board could not grant that type of motion.
And that's a fair and an excellent answer, right? Because I understand that, and the reason I say it's an excellent answer because the best answer I've ever heard in the courtroom actually came from somebody on your side once. When I asked a question, they said, "I have no idea," right? And so it made me feel much better. So
that's a valid answer.
So because the reason that that's important and why just speaking for myself, might very well try to seek some additional information from the secretary, is if it's possible that the board is going to treat this as, okay, this doesn't come around every single day, but we've got a motion to stay, and this is a really complicated case, and I think I can grant it, then that's an adequate alternative means, right?
That would be an adequate alternative means to this particular, to the particularly, the alleged harm. I believe that there's still adequate alternative means to the petitioner in the sense that the administrative appeals process that Congress created would redress the injury. The only thing that petitioner would have to do is temporarily stop engaging in SSVF-funded.
So, but fair enough, but you'd agree with me based on the argument that we've had today, right, that this is, I know Mr. Grayson says he sort of parachuted in, but the fact of the matter is anybody who thinks that you or I or anybody else here handles cases like this on a day-to-day basis is wrong, right? And so my point being, isn't it better maybe to let the board play out what its authority is in this area as an initial matter? What do you think?
It perhaps is, but to the extent that it protracts the Secretary's ability to terminate these grants, the Secretary would submit that the more prudent course would be for the court to address the arguments and find that it doesn't have the authority. Because regardless of whether there's alternative relief, the court doesn't have the authority to issue the requested relief in the first place. That availability of alternative...
You mean in this case?
In this case, yes. For the court to deny this petition based on its lack of authority to issue this particular requested relief, the court would not need to wait for the board to determine whether there's an adequate alternative remedy to the particular motion itself. But on the question of whether there's adequate relief generally, there is, and that is through the administrative appeals process. Because again, we're talking about a finite temporary termination of operations that if the petitioner is vindicated in the end, they will be able to re-engage in. The fact that they may have to lay off employees does not impact this court's jurisdiction. The fact that the petitioner may not be able to provide the services to veterans during an interim period does not impact this court's jurisdiction. So the answer here, Your Honor, is in that. It is in the fact that there may be irreparable harm, but even the Supreme Court in Scripps-Howard, which again concerned an order on review, recognized that irreparable harm alone is insufficient, because what we're talking about here is an intrusion into the administrative process, a process created by Congress, and one that is guarded by the separation of powers.
All right. Thank you very much. Do you have anything else? Mr. Morris? Anything else?
No, Your Honor. Thank you.
Thanks. We'll hear rebuttal, Mr. Grayson.
Thank you, Your Honor. Judge Allen, this is the Court of Appeals for Veterans Claims. Courts of Appeals hear motions for stay pending appeal all the time. That was actually my job when I clerked for the U.S. Court of Appeals for the District of Columbia Circuit in 1984 and 1985. I wrote the orders and decisions for the court about this. And I can assure you that I was a very busy person during that period of time. Courts of Appeals have to decide stays pending appeal every day. Not this court. This court has special jurisdiction. But this is an entirely pedestrian decision for a Court of Appeals to have to make. And it makes that typically applying the four-part standard that this court is familiar with. Now, the Secretary has argued that this court is constrained by the All Writs Act. I would suggest that we look at pages 7 and 8 of the brief that the Secretary has submitted. It reads as follows. This is about the All Writs Act. In limited circumstances, that protection of jurisdiction, referring to the protection of jurisdiction conferred by the All Writs Act, extends to enjoining the enforcement of an agency decision pending completion of review of that decision in the court issuing the injunction to prevent irreparable injury resulting from the premature enforcement of that agency decision. That's this case. That's exactly what's happening in this case. The brief submitted by the Secretary is describing the All Writs Authority as extending to the facts of this case. The brief goes on to say, a court may also, in addition to that, issue an injunctive order to preserve the status quo. While administrative proceedings are in progress, when absent that order, an ultimately effective court remedy would be virtually impossible. That's true here too. And the Secretary was citing Dean Foods, the case that it says prevents that relief, but in the Secretary's brief, it says it requires that relief.
So, look, before you sit down, right, let's assume I'm with you that the court has the authority to do this, right? Because, well, it doesn't come up every day. This is an example that might fit the bill. So we're a little hamstrung here because, of course, there were proceedings in the Southern District, so we have some material that were filed there. But, of course, those were under different conditions, and the letter was withdrawn and all of this. But there are real gaps in the sense that we don't have a lot of evidence about, and I know your position is that we don't need to go there, but likelihood of success on the merits. So, for example, we don't have the grants. We have the audit finding, but we don't have the submissions of your client to the audit finding. We've got the affidavits of the employees that are to either go to harm to the agency, to harm to your agency, or the public interest, potentially. What do we do if we think that there are evidentiary gaps here? Do we just say, too bad to you because you're the movement, or do we try to do what we can to ask for additional evidence? What's your view?
I think that the record is adequate to show that if we do need to show a likelihood of success on the merits or a possibility of success on the merits, that's been established in the record before the court. I devoted 10 pages of the opening brief in this case to the likelihood of success on the merits, and it was completely unrebutted by the Secretary. I gave you citations to regulations that I said were being violated by the Secretary, and there was no response. I also want to point out that before essentially the same record, with the same arguments, this is what the district court decided. This is May 18th, 2022, last year, Judge Cook. Plaintiff has shown on their filings, essentially the same situation, the same filings, immediate and irreparable injury, and likelihood of success on their claims. Same arguments, same situation. The only difference is they pulled back that decision and now they've reinstated it. Same facts. Plaintiff's filings contain affidavits detailing specific facts showing immediate and irreparable injury, loss, or damage if temporary relief is not granted. So Judge Cook had no difficulty answering your question, Your Honor, and it's been answered.
Yeah, but what do we do with the fact that you and I both know, my background's a little different than yours, but this was on a TRO, right? And so, judges are in the most vulnerable position, on the civil side at least, when they're faced with a TRO, because they know nothing about it. By definition, it's the world is going to end. And most judges do what in my experience, Judge Cook did, which is, except in the case of a patently frivolous claim, they enter the TRO and they schedule a hearing for the next morning, which is, I think, what Judge Cook did. Now, it got continued, and the government agreed that it was in place, right? So, I mean, you're not suggesting that there's any binding effect to Judge Cook's statement in that order, are you here?
It's collateral estoppel, but as to the findings she made, she did not have to decide that the foundation had likelihood of success in the merits, but she did.
No, she did have to find that as a formal matter in order to enter a temporary restraining order.
No, that's not my understanding. I don't think that that's a required finding for temporary restraining order. I think that it is.
You don't have to have the showing of success on the merits for a temporary restraining order? But
My understanding is that it's a sliding scale, and if you show enough irreparable injury, you don't have to show likelihood of success. Nevertheless, she did find likelihood of success on that record immediately.
All right, continue.
I want to jump to the end of what counsel said. Counsel said toward the end that the grant requires a transfer. As I said in our brief, if there's no possibility, there's no practical possibility of these veterans being served by anybody else, termination of this grant means termination of these benefits. There is no magic wand, there is no Ipsy Dixit, as Chief Judge Rehnquist said in his decision that I cited in our reply brief. By the way, just to confirm, if there's any member of the court who did not receive our reply brief that we filed yesterday, please let me know. We will speak to the clerk's office about that. I apologize for the last-minute filing. I just want to make sure you've had the benefit of it. But there is no magic wand here. I also want to address what counsel said, that the only place where this authority comes from is the All Writs Act. You can decide what you want to decide. It's your court. But as I read the plain wording of 5 U.S.C. 705, it applies here. As I read the plain wording of the Scripps-Howard doctrine, it applies here. In fact, the Secretary cited the Scripps-Howard case in its own brief favorably. So I'm a bit puzzled as to why the Secretary maintains that only the authority of the All Writs Act applies here.
May I ask, just a minute, Mr. Grayson, isn't it also a fact that Congress has never explicitly precluded this court from injunctive relief? Isn't that part of the inherent power of any United States court?
That is exactly what Scripps-Howard says. It is part of the inherent power of any U.S. court, particularly a court of appeals, that is trying to maintain the status quo and preventing irreparable injury while a proceeding is pending. That is exactly what Scripps-Howard said, Your Honor. As to the alleged closure of the business, actually, if you go back and look at the declarations that we submitted, the Eisenberg Declaration says that the business will be closed as a result of the terminations. So I don't think that alleged is the proper way to describe that. The notion that we could continue with the case if the company is out of business, if the foundation is out of business, is illusory. I can assure you that I charge for my services. This is not an eleemosynary institution being operated here. The foundation will have no money to pay for this appeal if it's cut off. And I want to end by saying that I think that Judge Greenberg has gotten this matter exactly right. The law provides the way that you should act here. We have a right under the law for this relief, but we also have to make sure that we see that justice is done. As the court said. Thank you.
Thank you. If there are no questions from my colleagues, I'd like to commend Mr. Morris, who always makes a persuasive argument, and Mr. Grayson, whose first argument it is in this court. You did a very good, excellent job. I commend both counsel. We will consider the case submitted, and if the court decides it needs something extra, we'll communicate with counsel. Are you going to greet counsel, Judge Allen, in the customary way?
We are, and don't be afraid, Mr. Grayson, it's just a handshake, so there we
Yeah.
go.
All right. The matter is submitted. Thank you. All rise.
Thank you. The Fourth Circuit does this too. I always enjoy that.
That's what we got.
Oh, really? Thank you. Thank you.